So what do all forensic psychologists have in common? The role of forensic expert. Regardless of what area of forensic psychology or where one works, the identification of expert is always pertinent. Before talking about the impact forensic psychologists have in court, it's important to understand the types of evidence generally presented in court. The first type of evidence is real or physical evidence. These are actual, tangible things that are relevant and material to the case. They can include the actual murder weapon, a written contract, or fingerprints. One rule of thumb is that real or physical evidence can often be brought into the courtroom, with an exception being something too large, such as a car. The next type is demonstrative evidence. These items are not tangible or the real thing. They are typically used for explanatory or illustrative purposes. They can be a visual aid for anatomical position, such as a map or a film. Because the purpose is to demonstrate something, a witness or expert must authenticate the evidence. Next is documentary evidence. These are usually a piece of writing or a record of some kind. They can also be court documents or newspaper clippings or recordings. As with visual aids, these must be authenticated in some way. Lastly, we have testimonial evidence that comes into court by way of a lay witness or expert witness. A lay witness has personal knowledge of the crime and can only testify to their perceptions. In other words, they can only testify to what they experienced through their senses, such as what they saw or what they heard, but they cannot speak to their opinions or speculations about what happened. On the other hand, an expert witness can interpret and express an opinion about a situation. For example, an expert witness may be called upon to determine whether the lighting produced by street lamps at night could have illuminated the suspect enough for a witness to accurately identify them. But why do we need experts to testify? Well, for one thing, we cannot expect jurors, judges, and legislators to know everything. As a result, people who have acquired specialized knowledge through education and experience, experts, are called upon to testify in courts or in front of legislative bodies. In courts, the process usually works like this. An attorney representing one side or the other in a trial proposes that a particular expert be allowed to testify, and the presiding judge decides whether or not to allow the testimony. See, the lawyer believes that the expert will strengthen his or her case, but the judge has other concerns. He or she must decide if hearing the expert testify will help jurors discover the true facts in a particular case. This is because jurors are the triers of fact. That is, in a jury trial, it is the jury that must listen to the evidence and decide on a verdict based on the facts presented at trial. If a judge decides that ordinary jurors already know what the expert has to say, or decides that the proposed testimony would only confuse jurors, or decides that the expert testimony would have too much impact on jurors, that judge can refuse to allow the testimony. So what are some of the rules of evidence? The first standard was set by Fry v. United States in 1923. The decision in this case held that expert scientific opinion was admissible only if the principles on which the opinions were based had gained general acceptance in the relevant scientific community. While this was an attempt by the court to avoid testimony by quote-unquote quacks, it prevented the jury from hearing expert opinions from accomplished scientists who were intellectually credible and yet novel or cutting edge, since they had not yet gained general acceptance within the relevant scientific community. Take a second and think about this, as it makes a lot of sense. Think about how long a study takes to conduct, and then how long it would take to write up the findings, and then the amount of time it takes to get something published, and then to get that information disseminated to the relevant community. It could easily take years for something to reach this standard. As a result, the Frye standard was unduly restrictive. 70 years later came the landmark case of Daubert v. Merrill Dow. In 1993, two parents alleged that their children's serious birth defects had been caused by the mother's prenatal ingestion of Bendectin, a prescription drug marketed by Merrill Dow Pharmaceuticals. Even though the plaintiffs, or the parents, presented testimony from 8 well-credentialed experts who based their conclusions that Bendectin can cause birth defects based on animal studies, chemical structure analyses, and statistical studies, the district court determined that the evidence did not meet the general acceptance standard. While the Court of Appeals agreed and affirmed the decision, the U.S. Supreme Court vacated or overturned the decision of the Court of Appeals, ruling that the federal rules of evidence, now referred to as the Daubert Rule, allowed for a trial judge to be assigned the responsibility of ensuring an expert's testimony is reliable and relevant to the task at hand. In other words, expert testimony can be admitted into evidence if, in the judge's opinion, the testimony would be relevant in assisting the jury in better understanding the case. Now, under Daubert, there is the opportunity for new science to be admitted into evidence. With regard to privileges, psychologists have psychologist-patient privilege. This privilege exists in all 50 states, and the purpose is to enhance the effective diagnosis and treatment of illness by protecting the patient from the embarrassment and humiliation that might be caused by a psychologist's disclosure of information that's been divulged over the course of treatment. In the course of treatment, the limits of this confidentiality do not apply if a client threatens to harm themselves, someone else, is a threat to national security, or their records have been subpoenaed. In either four of these situations, confidentiality must be broken. The limits of confidentiality from the previous slide may seem easy to discern, but it actually becomes quite complicated when it comes to the duty to warn others. The duty to warn gained national attention after the seminal case of Tarasoff v. Regents of the University of California in 1974 and 1976. In the case, Prosenjit Podar, a graduate student at UC Berkeley, killed Tatiana Tarasoff, a student who had repeatedly rejected his romantic advances. Prior to the killing, Podar had been receiving psychotherapy at the University Health Center, and during a session, he expressed his desire to kill Tatiana. Tatiana's parents sued the university, and the lawsuit was successful even though the therapist had alerted campus police that Podar had made a death threat against her. Campus police actually interviewed Podar and released him as they said he was not dangerous. In the case, the California Supreme Court held that psychotherapists had a duty to protect their clients' identifiable victims, meaning that they are required to notify police and/or the victim. There are a number of cases listed in your book that highlight the complexity of this issue, and I encourage you to take some time to read through them. This is the current duty to warn standard as set forth in Colorado. Take a minute and read through this standard. As you most likely noticed, the standard is complex and convoluted, with no clear direction on how to handle the situation. Some of the questions that come to mind are, if you suspect that one of your clients might be dangerous to someone, do you have a duty to warn anyone in particular? What if your client discloses a vague threat against a readily identifiable target with no clearly identifiable victim, such as a threat towards a shopping mall with no clear one subject? What if your client specifies no one at all? What if you have no ability to control or detain your client after he or she angrily walks out of your office after making a vague threat of violence? What if you notify the police and they determine he is not currently dangerous? These questions represent some of the most complex and troublesome ethical dilemmas that confront mental health professionals. Whereas the reporting of child abuse is mandated by law in all 50 states, the so-called duty to warn is more complex because the decision is usually based on the professional judgment of the therapist rather than on any clear legal statute. It is also important to note that recent consideration of applying the duty to warn has raised questions regarding the therapist's responsibility to breach confidentiality in order to report clients' nonviolent behaviors which may pose dangers to others, such as clients with HIV or AIDS who are currently sexually active and not informing their current partners. Lastly, I think it is important to spend a minute to discuss what research has found regarding what legal professionals desire from mental health professionals. With regard to the first point, it is somewhat problematic that legal professionals preferred psychiatrists to conduct forensic evaluations for the court, when, as we discussed earlier, the majority of their training does not include the behavioral or social sciences. Secondly, judges seem to want juries to have the benefit of hearing the judgments of mental health professionals. Judges and lawyers were relatively disinterested in statistical or actuarial data as compared with other types of testimony. And lastly, judges seem to prefer testimony that provided more information, even somewhat speculative testimony, such as theorizing about the causes of a defendant's behavior. Defense attorneys saw value on clinical diagnosis and mitigating factors for criminal behavior. As you can tell from all of the points, it seems as if legal professionals do not fully understand the relevance of scientific study. It is also important to know that law school does not include courses regarding mental health issues or the issues of psychology in court. As a result, most lawyers do not have an adequate knowledge of mental health issues or how they interact with the legal system.